safe custodian of the American Constitution and its chief interpreter? Or should one assume, because he's been, after all, nominated by the president, whose abilities to make personnel selections like Brownie at FEMA are legendary, but I have promised many people that I would not become partisan, so you will disregard that last comment. Should one assume that structurally, because after all the people elected, at least this time, elected George W. Bush president? I have to stop. I can't help myself. Elected Bush president of the United States, that he has a mandate, not necessarily because everyone voted for him to put people like Scalia and Thomas on the court, but he didn't hide anywhere his plan to treat them as the ideal, and so those who voted for him can hardly complain when they get someone that at least some people on the right fantasize might meet that ideal. And those who didn't vote, I suppose, can't complain because they didn't vote. But let me return, without resolving or attempting to resolve this burden of proof issue, to the biggest reason that Roberts gave for leaving us in the dark. Because if, after all, we are in the dark, but really only a dark of our own creation, or if the condition in which we find ourselves is lacking in light only by an unrealistic definition of what light would look like, well, then perhaps we can't complain at all. After all, we were given, as is repeatedly stated, some 80 to 100,000 pages of paper trail. This was the mother of all paper trails. You want paper? Here, 10,000 more pages. And you start reading that, and here's another 10,000. And the explanation for the adequacy of that trail, as I piece it together from the 2 days of testimony, is that first, we're missing only some parts the administration couldn't find on, for example, a topic like affirmative action. And he had written about affirmative action in the, not in his allegedly privileged communications to the Solicitor General in the first Bush administration, but in his communications in a staff capacity in the Reagan White House and in the Reagan Justice Department. Maybe those are with the travel entries that were lost in the White House residence during the Clinton years. I'm not sure they've looked. Second, the light that we've been shown is perhaps not adequate because Roberts' memos as the political deputy Solicitor General in the first Bush administration were allegedly protected by the attorney-client privilege. Now, that's a more complicated one. It's a somewhat glib rejoinder to that to say that the client of the Solicitor General of the United States of America is all of us, the people of the United States of America, not the particular occupant of the Oval Office at any given time. That's not the client. Solicitor General Kenneth Starr wasn't the client. The client was all of us. And we, through our agent, the Senate, have a right to demand the papers. The reason I call that glib is that if you think about it functionally, the point of that privilege is, after all, to secure adequate, candid advice to someone who is representing the United States, namely the Solicitor General. And it's not entirely surprising that every living former Solicitor General, including the Democratic Solicitors General, have all signed a statement agreeing that these papers ought to be treated as privileged. Besides, the culture of the Solicitor General's office is so gray that the likelihood that there will be found anything that smokes even halfway like a gun among those papers, compared with the fire that one sees in the fire-breathing papers that Roberts wrote when he was in his 20s, when, as he says, I knew everything then, I knew much more then than I think I know now, and who among you some of you surely are 25 or younger. Who among you would want to be judged when this will be the midpoint of your life by what you write when you are wildly enthused today? You might say, well, if I'm being considered for Chief Justice of the United States, hell yes. But easy for you to say that now, perhaps not then. But the third and most interesting reason that the light that was shed was not greater than it was is that, as Roberts explained, he wasn't at liberty to say very much. That is, in principle, under oath, he could be asked to say all kinds of things. What do you think of Roe v. Wade? Did you react at the time by thinking it should be overruled? After all, you surely have a view of it, even if Clarence Thomas could be believed when he said he had no view, never had a view, never discussed it with anyone. Everyone knows that you were very intellectually curious. You loved the law. You surely discussed it. You have beliefs about it. Why can't you share them with us and with the American people? Well, his answer to that essentially is, I would be compromised, fatally compromised. Who among you would want to argue before a judge who had said, when before this committee, here's what I believe about this or that issue, this or that precedent that could come before the court? And although that was an argument that the Judiciary Committee was pretty much stymied by in the past, they thought it through and this time had an answer. Their answer was, well, that happens to us all the time. Anybody who goes up before the current court knows from their prior opinions what Scalia thinks of almost everything that comes up. There are 2 abortion cases up next term. We know what he thinks about the underlying principles of Roe v. Wade. We know what Stevens thinks at the other end of the spectrum. Why shouldn't we know what you think? Now, there's a rejoinder to that. The rejoinder to that is, well, I'm different. Not I'm different from Stevens and different from Scalia, smarter than both. No, the point is, I'm before you under the Klieg lights of confirmation, and to extract a commitment or a promise from me now is to reduce this to a game of politics. I will have made a promise in order to secure my position. That will compromise my integrity in a way that expressing an opinion in the course of adjudication doesn't compromise theirs. But not to be outdone, the committee responds to that, okay, who asked you for a commitment? We don't want a commitment. Do you want a commitment? Do you want a commitment? None of us want a commitment. We know that would be improper. And if you gave us one, we would regard you as disqualified automatically. So please proceed. And remarkably, the nominee managed in every such instance to change the subject. As he basically would say something like, well, that was the Ginsburg rule. And somebody else would get lost in the details by saying, it was not. Ginsburg said she wouldn't talk about anything except her own past opinions and writings. But in fact, she talked about 24 cases other than that. Well, all I know is what she said was the rule, and I'm following that rule. And in fact, at one point he said, I think quite brilliantly, remember, if I'm to go to that court, I will need to look her and all of my other colleagues in the eye at conference and say, I kept the faith with the commitments you made. It won't do for me to say the commitments you broke. That is, there's a problem of collegiality if you want me to be Chief Justice. And that kind of silenced the committee rather effectively. And there's another difference, and he made this point also at one point, and it's interesting that I think on his feet, though this might have been part of the so-called murder boards that were the rehearsal, but he made a point that I haven't seen in any of the literature going back and forth on this, and that is that there is at least a technical, and maybe more than just a technical difference, between a statement of belief, even if it's short of a commitment, that's made under oath, and a statement of belief that's made in an opinion. It's one thing for Scalia or Stevens to say that on September 19th, 2005, I believed X, or I believe X. And then at a later point, when someone invokes that statement, the person can say, well, I've thought about it some more and I've changed my mind. Whereas if someone says, under oath you said you believe X, they have a kind of higher burden, a burden of a moral kind, because you now have to prove that you've changed your mind. It's an interesting argument. To me, not one that has great force, but what has much greater force